And now go to the mens rea. Presence of any of the three kinds of guilty mind is culpable homicide. Presence of any of the following. Three kinds. There are three kinds of mental element in the section 299. One is intention to cause death. Intention to cause bodily injury as is likely to cause death. Third, knowledge that death is likely to happen. So, what type of mens rea are required? There are two types of mens rea, either intention or knowledge. The intention is relating to intention to cause death or intention to cause bodily injury. That injury is likely to cause death. Third one is knowledge. Intention and knowledge are the mental element required for the culpable homicide. What is an intention? Intention means expectation of the consequences of an act. Intention means the expectation of the consequence of the act. By doing the act, you are expecting, you know what is the consequence. By doing an act, you know what is the consequence, what is the result of the act. If you set a fire to the hut, you know the consequence. The hut gets damaged. Pulling the trigger, aims at B and pulls the trigger, clearly shows that B dies. You know the consequence. If once the accused knows the consequence, it is called the intention. There is one case, R. Venkulu. The accused had an intention to kill the deceased. So what he did, he locked the outer door of the hut and poured the petrol and set the fire to the hut. Because he had an intention to kill A, who was in the hut. When the neighbors surrounded by him, he threatened all them with the pistol. So it clearly shows that he had an intention to kill A. That is expectation. He know by pouring a petrol and setting a hut where A was sleeping in the hut clearly shows that he will die. Expectation of the consequence. That is the intention. But there is a difference between the intention and motive. Many of the lawyers are depending on the motive. They are making an attempt to prove the motive before the court of law. Motive is irrelevant to the criminal law. Don't touch the motive. It is the intention. That is the state of the mind. How to distinguish motive and intention? If you put a question, why he did the crime? If you put a question, why he did the crime, you will get the answer of motive. That is motive. That is not relevant to the criminal law. Why? How he did the crime? That is the intention. How he did the crime has to be proved before the court. Motive is irrelevant to the criminal law. But motive will be taken into consideration only in awarding the punishment. Suppose a person commits a theft because of starvation. He wants the food. He stolen a loaf of bread from the shop. The motive is nothing. Because of starvation, he committed a theft of loaf of bread. Punishment will be reduced. The court will reduce the punishment if the motive is good. That is different. Whether he has committed an offense or not, intention plays an important role. Mens rea plays a very important role. So it is to be proved before the court of law, whether it is the prosecution or the defense, that how he did the crime. What is the state of mind? What is the intention? These are the things to be proved. Intention. What is the knowledge? Intention and knowledge has a very thin line of differences. When intention is not able to prove, then the prosecution may depend on the knowledge of the accused. Suppose that is the knowledge, he had a knowledge, by doing this act, death can be caused. So he had a knowledge that I am doing this act. With this act, he may die. if he had the knowledge, even though he does not have an intention. He does not have an intention to kill B, but he had a knowledge that by doing this act, the B may die. The death is likely to cause. Then it is a culpable homicide. If the knowledge was not there, then it amounts to the accident. Accident. These are the 4 classes of section 300 IPC. There in the 299 there are only 3. Intention to cause death, intention to cause bodily injury as is likely to cause death, and the knowledge that the act by likely to cause the death. But here there are 4 classes under section 300 IPC. If section 299, so far we have discussed about all the ingredients, falls in any one of the 4 classes, it would amount to the murder. What is this? First class, with the intention to cause death. Second, with the intention of causing such bodily injury as the offender knows to be likely to cause the death. Third, with the intention of causing bodily injury to any person sufficient in the ordinary course of nature to cause the death. Fourth, persons committing the act known that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death. These are the 4 classes under section 300. If culpable homicide falls in any one of the class, then it would amount to the murder. There are 5 exceptions under section 300. These 5 exceptions are amount to culpable homicide not amounting to murder. Not amounting to murder. So these 5 exceptions are given under section 300. So 300 consists of 4 classes which we have seen in the previous slide, and these 5 exceptions. Sudden and grave provocation. Under the provocation he caused the death. Death caused in exceeding the limits of right of private defense. So one person can exercise right of private defense, but there are certain limitations and restrictions imposed by law within which he has to exercise the right of private defense. But once he exceeds the limitation and causes the death of any person, he falls under this category. Suppose A made an attempt to kill B with a pistol, but A immediately throws a big stone on him and causes the death of B in order to protect himself. That killing was justified. That is equal. B is made an attempt to kill A, in turn A kills B in order to protect himself. That killing was justified. He acted within the limitations. Suppose B took a small stick and made an attempt to beat A. B took a pistol and fires at B. He exceeds the limitations. Once he exceeds the limitation and causes the death, that amount to the culpable homicide not amounting to murder falls under exception 2 of section 300. Third, offences committed by a public servant or some other person acting in the aid of such public servant. Either the public servant or any person who is assisting to the public servant. So while they are doing the advancement of the public justice, causes the death, exceeding their limitations, exceeding their power, it is a culpable homicide not amounting to murder. Death must be in sudden fight without premeditation. There is no pre-plan. There is no plan. So the fight started between the 2 parties. A sudden fight has been started between the 2 parties, and one of the fellow in one party kills the other person in the other party. So this is not murder because they don't have any intention. They have not planned. There is no premeditation. All of a sudden fight starts between the 2 parties. One person killed the other during that fight. This is also a culpable homicide not amounting to murder. And the last, death caused of a person consenting to it. So a person decided to die. So he gave a consent and asking the B to kill. And here the person who gave the consent must be above the age of 18 years. B, for example, A and B. B is above the age of 18 years and he gave a consent to A. He was requesting the A to kill him. And A kills B. A is held guilty for the offence of culpable homicide not amounting to murder, falls under exception 5 of section 300. These are the 4 explanations and 5 exceptions. The 4 explanations, if section 299 falls in any one of the explanation, falls in any one of the class, any one of the section 299 falls in any one of the class, it would amount to the murder. If the murder is committed in any one of these circumstances given under general exceptions, 5 exceptions given under section 300, then it is called the culpable homicide not amounting to murder. Sarbit Singh was a state of UP, Tangaya was a state of Tamil Nadu. In both the cases, the Supreme Court held that certain factors can be taken into consideration for determining whether the death is culpable homicide or murder. So, whether the act of the accused is falls in the culpable homicide or murder can be decided by taking certain factors. What are they? Weapon used. What type of weapon he is used? What type of weapon he is used? Whether he took a lathi or a stick or a gun or axe, hammer, pistol, gun, weapon used. Deadly weapons. If it is a deadly weapon. Second, seat or place of injury. Where he inflicted the injury? In the vital part of the body, in the heart or on the forehead? Where he had inflicted the injury, or on the leg or the hand. Third, ferocity of attack. What is the force? Ferocity of attack. How he attacked. Taking an axe and forcibly cut into the body of the B into pieces. So clearly it is a murder. Clearly it is a murder, the ferocity of attack. And other is the state of mind of the accused. State of mind, mental element. See, weapon used, seat or place of injury, ferocity of attack, and the last is state of mind of the accused. What is the state of mind of the accused? It is the mental element. Here I will quote one example. Actually, this is the example given by the Stephen. Professor Stephen has written 3 volumes. The last volume is relating to the Indian Penal Code. In the Indian Penal Code, he has given one example, and there he used a snow, and now I am using a stone. See, what is the state of mind makes the differences. 3 essential elements are required for any offense. So in the homicide, the physical act is throwing a stone from the roof of the house. What is the physical act? Throwing a stone from the roof of the house. What is the consequence? Death of B. Death of B. Now I am giving 5 different illustrations. I am giving 5 different illustrations. In all 5 illustrations, physical act and consequence is the same. What is the physical act? Throwing a stone from the roof of the house. Consequence, death of B. These 2 are common in all these 5 illustrations. First we will take the illustration. A having an intention to kill B. He knows that every day the B in the particular time will pass into that direction. So he was waited there on the roof of the house while he was entering into that near. When he comes almost near, he throws a stone from the roof of the house. It fell on B and B dies. So he planned it. He had an intention to kill B. So this is a murder. This is a murder. See, throwing the stone from the roof of the house, B dies. But he had an intention. So he waited. He knows. He planned. He killed. It is a murder. Now take the second illustration. He does not have an intention to kill B because he don't know who is the B also. There is no relation between. He never saw B. So he had no intention to be. He don't know who is a B. But he throws a stone from the roof of the house in a very, very busy, crowded area at evening 6 o'clock. Even the child can say that definitely it fell on somebody and it will kill. He will kill. Because it's such a busy, crowded street. Because it is such a busy, crowded street. So he throws a stone and it falls on the B and B dies. He does not have an intention to kill B, but he had a knowledge. Throwing the stone from the roof of the house in the busy, crowded street, that too in the evening 6 o'clock where the crowd is heavy. In such situations, definitely it will fall on any one of the passerby and it causes the death. So it fell on B and causes the death. It is also a murder. It is also a murder. Again, third illustration. Same place, but in the afternoon where the crowd is less. Where the crowd is less. He throws the stone, but again it fell on B and B dies. It is a culpable homicide, likely to cause death. Likely to cause death. So it is a culpable homicide in the third category. Fourth, in the morning 6 o'clock, same place, he thrown a stone from the roof of the house. But still it falls on B and B dies. This is a negligent. This is a negligent act, death caused by negligence. Now, the last illustration. He took all precautions. What are the necessary precautions necessary to throw a stone from the roof of the house? He took all the precautions. But still it falls on B and died. It is an accident. It is an accident. See, same. Physical act is the same. Consequence is the same. But it is a murder, one it is a culpable homicide, other is a death caused by negligence, and the last is accident where there is no punishment. What makes the difference? Physical act is same, consequence is same, but the state of mind of the accused and the probability of the risk, danger of the life. So throwing a stone at 6 o'clock where the crowd is more, or throwing a stone in the same place in the afternoon, throwing a stone in the morning, probability is less. That is, risk of life is less. The risk of life and the state of mind, that also be differences between the culpable homicide and murder. These are the examples. We can say that stabbing another person with a knife in the chest or abdomen, it is a murder. We can say that very clearly that where he stabbed, where is the seat or place of the injury, what is the weapon used, what is the ferocity of attack, it is a murder. Similarly, several persons attacked a single person and started giving a blows. One blow fell on the head and died. This is also a murder. And with a hammer in the head, which resulted in the breaking the bones of head. This is also a murder. So the weapon used, place of injury, ferocity of attack, these all will be taken into consideration to decide whether it is a murder or culpable homicide. So this was held by the Supreme Court, and the Supreme Court has given some clues how to make differences between the culpable homicide and murder by applying these factors. Reg versus Govinda. This is a very, very important case. In 1877, this is the first case where it draws a distinction between the culpable homicide and murder. The accused kicked his wife with a fist blows and gave her few blows on the body. With the result, she fell down on the ground. Then he put one knee on her chest and again struck her with a few more blows, resulting in her death. So the husband gave a fist blows. The wife fell down on the ground. Again he put one knee on her chest and again started giving the fist blows, and the wife died. These are the facts of the case. The lower court convicted him for the offense of murder. On appeal, this case is referred to two bench judges. One judge says it is a murder and other judge says it is a culpable homicide. Difference of opinion. So this matter is referred to this case was referred to the Justice Melville, a third judge. It is the Justice Melville who draws the distinction between culpable homicide and murder. He convicted the accused person under Class B of Section 299. What is Class B of? Because what is the act done by the accused? He gave a fist blows. So this is the weapon is not shows has an intention to kill wife. It is not. Suppose if he took a knife or gun, etc., we can say that he had an intention. But he doesn't have any weapons. Just he gave the fist blows to the wife. Clearly shows that he had only an intention to cause bodily injury. His intention was not to cause the death, not to kill the wife, but his intention was only to cause bodily injury by giving the fist blows. But that injury, that bodily injury is likely to cause death. The wife dies. So falls under Class B of Section 299. He was convicted culpable homicide under Class B of Section 299. And this is the table where after Justice Melville made a differences. Here culpable homicide Section 299 consists of A, B, C, and Section 300 murder consists of 4 classes. A is to be compared with the 1, B is to be compared with 2 and 3, and C is to be compared with 4. What is A? Section 299 culpable homicide, under culpable homicide Class A with the intention to cause death. What is Class 1 under Section 300? It is also intention to cause death. What is it? In both the cases 299 and 300, in both it has intention to cause death, because in culpable homicide it includes amounting to murder and not amounting to murder. Culpable homicide includes amounting to murder and not amounting to murder. So A is amounting to murder and B and C is not amounting to murder. So whenever you find an intention, whether it is 299 or 300, it is always a murder. It is always murder. So now compare B, Class B of Section 299 with 2 and 3 of murder 300. See, all the 3 are same: intention to cause bodily injury, intention to cause bodily injury, intention to cause bodily injury. It is likely to cause death. Here the offender knows likely to cause death, and in 3 it is sufficient in the ordinary course of nature to cause the death. And last, knowledge that he is likely to cause death and it is imminently dangerous to cause the death. Now we will go to the explanation one after the other. Not only the Reg versus Govind, in the latest, the Abdul Wahid Khan versus State of AP, the Supreme Court again repeated the differences between the culpable homicide and murder, and there is no much difference, the distinction drawn by the Justice Melville and the Supreme Court in Abdul Wahid Khan versus State of AP. The Supreme Court observed Class B of Section 299 corresponds to Class 2 and 3 of Section 300. First compares Class B Section 299 with 302. You read, if you read the both the sections, it is not intention to cause death. Their intention is to cause bodily injury. Section 299B is intention to cause bodily injury. Class 2 of Section 300 is also intention to cause bodily injury. 299 is likely to cause death. But in Section 300, the offender knows to be likely cause death. See, knowledge of the offender is extra element you will find in the murder. Rest is same. Intention to cause bodily injury, likely to cause death. Here is also in the murder also, it is intention to cause bodily injury, but the offender knows. The offender knows to be likely to cause such death. What is the knowledge? That is the difference between the culpable homicide and murder. Under class B of section 299 and class 2 of the section 300 is only one point, that is knowledge possessed by the offender. If the offender possesses the knowledge, it is the murder. If the offender doesn't possess the knowledge, it is a culpable homicide. So what is the difference between class B of section 299 and class B of section 299 and class 2 of section 300? Is the knowledge possessed by the offender. With what respect? Knowledge the offender possessed. That is the knowledge regarding the particular victim, not in general, particular victim, being in such a peculiar condition or the state of health that the internal harm caused to him is likely to be fatal. What is the knowledge? We said that the knowledge possessed by the accused makes the difference between the culpable homicide and murder. If the offender had the knowledge, it is a murder. If the offender does not possess the knowledge, it is a culpable homicide. With what respect the offender should have the knowledge? Regarding the peculiar condition or state of health of the victim. Peculiar state or state of health, peculiar condition or state of health, peculiar condition or state of health of the victim. He knows. If the accused knows the state of health of the victim, it is a murder. If the accused has no idea about the health of the victim, he doesn't know the health of the state of the health of the victim, he doesn't know that he was in a peculiar condition, then it is a culpable homicide. I will explain with an illustration. First take the culpable homicide. A and B. A inflicted a bodily injury on the B. No, let us take murder so that you can understand very easily what is a culpable homicide. I will take illustration with the murder. A inflicted a bodily injury on the B. Now B was suffering with some disease, enlarged spleen or enlarged liver, or he had a heart patient. That was known by the accused. Accused know what disease he had. He know the state of health of the victim. He know the peculiar condition of the victim. Knowingly, he inflict the bodily injury. And knows that this bodily injury causes the death, accelerates the death because of the peculiar condition of the victim. Now there was an enlarged liver or the heart patient. Knowing the condition of the victim, if the accused gave a blow in the abdomen, if the liver ruptures or the heart become failed, thereby accelerates the death, he died, he is held guilty for the offense of murder. Now come to the culpable homicide. B was suffering with an enlarged liver or he is a heart patient, but he doesn't know about the state of health of the victim. He do not know. He don't know that he was suffering with a heart patient or there was an enlarged liver. He inflicted the bodily injury. The liver ruptured and died. It is a culpable homicide. So what is the difference? How you make the difference between the culpable homicide and murder with respect to class B of section 299 and class 2 of section 300? Knowledge possessed by the accused about the health of the victim. Suppose the same bodily injury is inflicted to any other normal person. it doesn't result into the death. Because of its peculiar condition, death results. Suppose if the same injury is inflicted to any normal healthy person, such injury is not sufficient to cause the death. Such bodily injury is not sufficient to cause the death of the victim. But still, why it causes the death? Because of the peculiar condition of the victim. Because of the disease he possessed inside the body causes the death. So he is liable. So the knowledge makes the difference between the culpable homicide and murder. In both the cases, that is class B of section 299, class 2 of section 300, there is no intention to cause death. Intention to cause death is not an essential ingredient. Their intention is only to cause bodily injury. It is not intention to cause death. And these are the instances, cases which just now I explained, that is the enlarged spleen or enlarged liver, diseased heart, etc. So this is the knowledge is possessed and inflicted the bodily injury, it is the murder. Now let us come to the 299B with class 3 of section 300. Again, if you read class B of section 299, intention to cause bodily injury, class 3 is also, class 3 of section 300 is also intention to cause bodily injury. But in 299, that bodily injury is likely to cause death. That injury is likely to cause death. But in class 3 of 300, it is sufficient in the ordinary course of nature to cause the death. Whenever the prosecution fails to prove the intention of the accused, then they will depend on this. What type of injury is inflicted? Whether the injury is sufficient in the ordinary course of nature to cause the death, so further generally they will take the doctor's opinion. The doctors will explain that this much of inches to the abdomen, there has been a knife has been inserted into the abdomen and so on. The doctors gives the opinion, and if they said that it is sufficient in the ordinary course of nature to cause the death, it is a murder. But in 299, the bodily injury that is inflicted is not sufficient in the ordinary course of nature to cause the death. Whether the injury inflicted was sufficient or not to cause the death of a person in the ordinary course of nature, it is a murder. If it is not sufficient, it is 299 class B. So what is the degree of probability has to be taken into consideration. And Veer Singh was the state of Punjab, 1958 case. The Supreme Court held that first you have to see whether the bodily injury is present or not. Second, nature of the injury must be proved. First, bodily injury is present. Next, nature of the injury must be proved. There was an intention to inflict that particular injury. It must be proved that injury is sufficient in the ordinary course of nature to cause the death. If these 4 points are established, proved, then it is a murder. Bodily injury, that bodily injury must be, nature of the injury must be proved. That is how much inches the weapon has inserted into the body, what is the force, the description of injury, nature of the injury has to be proved. Then intention to inflict that particular injury, he had an intention is to be proved, and it must be proved that the injury was sufficient in the ordinary course of nature. Then it is a murder, falls under class B of section 300. This part of inquiry is purely objective and inferential and has nothing to do with the intention of the offender. Intention of the offender is not necessary to prove it. Just saying that it is sufficient. And let us come to the last class, section 299 and class 4 of section 300. Both require knowledge. Both require knowledge. In simple, we can say that what is the difference between the culpable homicide and murder with respect to knowledge? Degree of probability of risk of life. If it is likely to cause death, it is culpable homicide. It is imminently dangerous, it is a murder. To disperse the mob, firing in the air or firing at the mob. Firing at the air, less likely to cause death. But firing at the mob to disperse, definitely it will hit some person. There was imminent dangerous and it amounted to the offense of murder. So first class A is intention to cause death, it is always murder. B and 2, B of section 299, 2 of both are bodily injury, but here the offender possesses the knowledge regarding the condition of the victim, and he knows that this injury will cause the death of the victim. That knowledge was absent in section 299. And 299 class B and class 3 of section 300, the injury inflicted was sufficient in the ordinary course of nature to cause the death, but in 299 the injury is not sufficient to cause the death. And the last, both are relating C and 4 is knowledge. Knowledge is likely to cause death, less danger is culpable homicide, more imminent danger is called knowledge, that is murder. So the example which I have given, the illustration, throwing a stone from the roof of the house in the very busy crowded area in the evening 6 o'clock, it is a murder. Imminent danger, imminent danger. The same thing is dropping in the afternoon, that is culpable homicide. That is the difference between the knowledge likely to cause and imminent danger. This is the differences between the culpable homicide and murder, and the differences is very fine but real if once you overlook the miscarriage of justice results. So one should be very careful in drawing the distinction between the murder and culpable homicide. Otherwise miscarriage of justice results. It is very fine. You should be careful. So this is the difference between the culpable homicide and murder. So there are certain cases also you can refer.